Hello, I'm Dr. Tom, and I'm a mining engineer retired. And today I'd like to go over the history, the facts, and laws regarding our 140-year-old private property that now the Bureau of Land Management is trying to take using regulations and ignoring federal laws. A little bit of history. We're going back in time to 1882 and before. And during that time was the first electric lights in Manhattan. Scientists discovered helium for the first time. The adhesive bandage and electric fan were invented. And typewriters, manual typewriters, were becoming used in the large cities. The first car was invented in 1886. Gas-powered cars were invented in 1892. This is kind of perspective of the history. And just 9 months before this became private property, Wyatt Earp and Doc Holliday had a shootout in the OK Corral. Now, Grant County has a long history of mining, with gold being discovered in June of 1882, which led to a gold rush. And as in most of the West, there were mining districts, local laws, rules, and customs found for claim locations, mining, size, access, etc. And in the drainage itself, where this mine is and this private property is, there were close to 30,000 ounces of gold, which now is equivalent to over $50 million, with silver, bismuth, cobalt, copper, lead, zinc, and uranium. So this is a very active mining district. Now, dynamite came to the U.S. in 1896, and in 1880, Grant County and Baker County established their line, and in 1881, the year before, the John Day River Road, the Harney Camp County Road, the Fox Bear Creek roads were established. And road supervisors at that time were required to post a bond. So it was very serious business getting a road established. A little bit of mining history. There was an Astra on the now current patented property. Now, an Astra, and I don't know if this horse was horse-driven or mule-driven or whatever, but you put the rock in and you crushed it and liberated the gold minerals. And you can see the picture here of the gold that's in quartz. You had to break that quartz to liberate the gold so you could pan it, like in the picture. Different than, it's called hard rock mining, which is different than Gold Rush, Alaska, which is placer mining. Okay, on this private property was the first smelter in the country. Once the road was built and established, they put up a smelter. And there's a picture of the actual base of the smelter on our private property today. And it was to pour gold bars. The miners had this Astra. They needed a road to the county road. So they went to the Grant County Commissioners in July of 1882 and requested a private road, which was granted to them. There's actual documentation in the Commissioner Journal, Book C, page 380, 381, in Longhand. This is before typewriters made it to Grant County. And it was a location of private road, according to law. I tried to get the best decipher of that curtsy. Beautiful curtsy, but it was tough to read. And the road started at the Astra, which was a gold mill, down the creek to the county road. And it had no connection with any county road or public highway. And so they located a private road. And they paid $50 for such location, which is equivalent to 2.5 ounces of gold. And that was equivalent to about 42 days of labor for the average worker at that time. So this 30-foot wide road, a little over a 0.3 mile, about a third of a mile, in equivalent was worth about $45 an acre. Now, at the time, a homestead was going for $1.25 an acre, which means that these miners paid over 3,500, almost 3,600% of what a homestead land was purchased for. Now, patented land was going for $5 an acre, so roughly 900% overpaid. So this road was pretty important to these miners to get ore to their Astra, or to their smelter, and then the final gold to market. Now, this is very steep ground. There were no dozers at the process. This was done with pick and shovels and horses. There's $50 plus the cost to build this road, which is quite extensive. Here we go to the patent survey, which shows the location of the quartz mill. It was documented in the mineral survey, which said in the second line, quartz mill. And this is from the 1901 patented survey. To get patented land, you have to have a mineral survey done to tell you exactly where your private property is. And patented mining claims become private property, and there's been taxes to the state of Oregon paid ever since it was patented in the early 1900s. According to law, the good question. So I looked that up and found that the Oregon statutes actually had the location of a private road. Notice the third line, for a private road leading from the premises to some convenient public road. So this location by the county was according to law. And interesting enough, that the U.S. Department of the Interior hired Honorable Clarence King in 1885 and 1886, and he reviewed all the mining laws in the West. And on page 202 in his publication to the Department of the Interior, they had Oregon laws in page 202, chapter 50L, and it has exact how you located a private road. In 3 lines from the bottom, mark out private road 30 feet in width. And that's exactly what happened. And what law, federal law, is that under? Well, in 1866, the Congress passed the mining law, which states is subject to regulation as prescribed by law and subject to the local custom and rules of miners in the several mining districts. They wanted folks to go out on the public domain and develop mines, minerals, grow America. And also in that same law, in the absence of necessary legislation by Congress, the local legislature or any state or territory may provide rules for working mines involving easements, according to law. In the 1872 mining law, which delineates how you state claims, etc., it also states that regulations prescribed by law in accordance with the local customs, rules of miners, and in several mining districts, as far as the same, are applicable and not inconsistent with the laws of the United States. And previously, you can see that the United States Congress wanted to open this territory. According to law, on the actual patent that was signed by the President Theodore Roosevelt in 1903, we have that Oregon may provide rules for working the mining claims or premises hereby granted, involvement, easements, drainage, etc. Now it's in our U.S. Constitution. Amendment number 5 of the Bill of Rights. No private property should be taken for public use without just compensation. And then the Congress passed the Federal Land Management Policy Act in 1976. And under that new law, it states several times in that law, existing right-of-ways of right-of-way use will be unaffected. Right-of-way or rights of use therefore issued, granted, and subject to valid existing rights. In addition, in that same law, we have patents, right-of-ways, and under land use rights authorized existing at date approval of this act. Also, it says subject to valid existing rights. Also, it says any vested right in existence on August 30th, 1949. This road was established in 1882, so it falls under this law quite clearly. Also, the Public Land Management Policy Act 1976 states a constitutes a violation of any law or regulation pursuant to state and local land use plans or program. And this was very clearly established under state law. In the body of any, also coordination with the local state government, body of any provisional subdivision of the state must regulate or change any amended land use zoning or other regulation concerning the use of such land. And so federal law states that the Bureau of Land Management must coordinate with the local, county, political subdivision on all their land use plans, zoning, and regulations. Then we found an excellent case law in U.S. District Court that's regarding these laws and access. And the local legislature of any state or territory may provide rules for working mines involving easements. The judge cited that the roads or right-of-way has some value and with property. And this grant acceptance for all that was necessary to pass the government title to the right-of-way, vested it in the grantee permanently. The way appropriately ceased to be a portion of the public domain, was withdrawn from it, and the land through which it passed were disposed of, subject to the right of the road company, which is us as predecessors, and right being reserved in that grant. Title of the U.S. to the right-of-way passes from the U.S. and vested in the defendants, the predecessors, and ceased to be a portion of the public domain. Does the BLM say it's public domain and our unlocked gate is in trespass, which is this judge did not rule in their favor. Also, in addition, Grant County passed 2 ordinances, one of which said the right to travel is in truth a personal right in 1994. And then again in 2013, but I'll get to that in a minute. So the county in 1995 wanted a county road through up there. And so we went to 2.5 days of trial. The BLM testified for several hours. The judge ruled that the county and the BLM failed to prove that this 1882 road is a public road. So the judge has already ruled on this issue, but it's a state court, not a federal court. This is the second ordinance that's put forth by Grant County. Hone in on, therefore be ordained, the safety and well-being of the county citizen, all roads, trails, stock grave, and byways over and across public land within the boundary of Grant County, Oregon, shall remain open, historically and customarily utilized, important because it has been customarily and historically been utilized as a private road, consistent with the Grant County plans and policies, unless otherwise authorized for closure by the Grant County Court and the Grant County Sheriff. Now, the BLM recognizes that the mining laws allow for development of local rules that are consistent with federal law, i.e. the 1866 and the 1872 mining laws. What we have here is the gate. And in 2013, because we had a lot of criminal activity, we asked the county commissioners what we should do. They recommended put an unlocked gate on it. So the gate has now been up there 10 years. This is a gate in which the Bureau of Land Management says is in trespass, definitely within the 30 feet. And it's used by a local miner. It's the Grant County Sheriff. It's been firefighters, including BLM firefighters. And just last year, there were 5 times Oregon Department of Forestry fire trucks went through there, which we encourage. The actual posts only occupy less than 1 square foot of land. But yet the Bureau of Land Management wants to charge us with trespass with $20,000 worth of fines. Now, they did a resource management, road management plan back 10 years ago. We commented quite extensively, and they were going to close our private road and all the roads connected to this 1882 road. Now, they decided instead to take our private road and make it a public road, but all other roads connected to it are closed. So that 1/3 of a mile private road goes nowhere but to our property. So BLM's argument, take this road for the public, is absolutely ridiculous. It is tyranny. It is action by the administrative state to bully us and to take our private property. This is a trespass notice they pay with a $20,000 fine and administrative costs. So the conclusion, the Bureau of Land Management completely ignores the U.S. Constitution by taking our private property, equal enforcement of laws, completely ignoring the 1866 and the 1872 mining laws, as well as the local custom, regulation rules, and culture for mining, as well as the Grant County rules and plans, and the Federal Land Management Policy Act. They must accept valid existing rights and must coordinate with the local government. And then also U.S. state law that I cited, U.S. District Court case, the Oregon mining laws, and Grant County ordinances. In their notice of trespass, they do not mention any of this, completely ignore it. So we ask you to contact your U.S. representative and U.S. senators and request the BLM to do the right and legal things for its neighbors. We're surrounded by Bureau of Land Management. In our experience, they're terrible neighbors. They're bullies. And please contact Representative Cliff Bentz, and there's his website and his phone number in a local Medford, Oregon office, and express that you want the right thing done, the legal thing done for us, and prohibit the BLM tyranny. Now, incidentally, just 1 mile north on BLM land, there's a lock gate. And when we made the presentation to the Grant County Commissioners, we got a letter in support that was issued the 20th December, just last year, 2022, that the BLM lied to the commissioner and said this lock gate was on private land. It is not. It is very clear from the surveys, etc., that it is on public land. They lied to the commissioner to try to get some advantage, which I don't understand. Anyway, the U.S. Constitution requires equal protection under the law. They ignore that. Also, within a quarter mile of this unlocked gate are a homeless camp, in which they've been there for over 6 months. Also, we've had illegal firewood cutting on the road before the gate. We've also had damaged gates. When they let open gates, cows come in on the property, etc. I've had problems with my spring in the garden, etc., because of the cow damage. Okay, there's also been theft of cameras, building material, and vandalism, littering, etc. You can see the litter. I don't have my camera with me all the time. We can't catch all of it, but there are people who've been doing donuts in the meadow, stealing my 2x12 when I'm building my house, shooting out my signs, etc. And so in conclusion, I ask you to contact your senator and your representative and bring the just thing so the Bureau of Land Management is reduce the tyranny and the unjust actions upon it. Thank you so much.